So friends, Donald Trump and his little minions like Stephen Miller and others find the Constitution really inconvenient because it's stopping them from doing what they want to do. Fortunately, federal judges continue to insist that Trump's executive branch abide by the Constitution. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump really wants to deport folks, doesn't he? I mean, starting with immigrants, but does anybody doubt that he'll make his way to imprisoning and deporting his political opponents and heck, anybody who displeases him? But there's a problem for Donald Trump, a real challenge. It is that pesky constitutional right of due process, notice, and opportunity to be heard by a judge, because it's not Donald Trump who makes the ultimate decision whether somebody can be properly detained and deported. No, it's a judge. And Trump and Stephen Miller and those of their ilk don't like that one little bit. So they're cooking up a new scheme. And federal judges are sounding alarm bells. Let's start with some new reporting in Politico. Headline, judges warn Trump's mass deportations could lay groundwork to ensnare Americans. And that article begins, a fundamental promise by Americans' founders that no one should be punished by the state, by the government, without a fair hearing is under threat, a growing chorus of federal judges say. And here's what some of those federal judges are saying. Quote, when the courts say due process is important, we're not unhinged. We're not radicals. U.S. District Judge Anna Reyes, a Washington, D.C. based appointee of President Joe Biden, said at a recent hearing, quote, we are literally trying to enforce a process embodied in probably the most significant document with respect to people's rights against tyrannical government oppression. That's what we're doing here, okay? And friends, it's not just judges who were appointed by presidents who happen to be Democrats that are sounding the alarm about what Trump and company are trying to do. There's this from a judge appointed by President Ronald Reagan. Quote, if today the executive claims the right to deport without due process, and this was Judge Wilkinson speaking about immigrants in the context of the Abrego Garcia case, if the executive, the president, claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? Wondered J. Harvey Wilkinson, a Ronald Reagan appointee to the Richmond-based Fourth Circuit Court of Appeals. Judge Wilkinson described an incipient crisis, but also an opportunity to rally around the rule of law. And in the Abrego Garcia opinion, Judge Wilkinson went on to say this, and what assurances shall there be that the executive, the president, will not train its broad discretionary powers upon its political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to take care that the laws be faithfully executed would lose its meaning. And friends, can I reference just one more judge, or actually in this case, a Supreme Court justice who believes that the constitutional due process right of notice and opportunity to be heard by a judge are pretty damn important? It's a fight that judges are increasingly casting as existential, rooted in the Fifth Amendment's guarantee that no person shall be deprived of life, liberty, or property without due process of law. The word person, courts have noted, makes no distinction between citizens or non-citizens. The Supreme Court has long held that this fundamental promise extends to immigrants in deportation proceedings. In a 1993 opinion, Justice Antonin Scalia called that principle well established. That's right, friends. Supreme Court Justice Antonin Scalia. It doesn't get any more conservative in recent generations on the Supreme Court than Justice Scalia. And he said it is well established that citizens and non-citizens enjoy due process rights. But Donald Trump and Stephen Miller don't like that. They don't like the kind of things that Reagan-appointed Judge Harvey Wilkinson say about how everyone, every person enjoys due process rights, notice, and opportunity to be heard by a judge. They don't like courts having their say. They don't like the Constitution having its say. Donald Trump doesn't seem to be fond of the whole checks and balances that are necessary to the lawful operation of our government. So they are hatching a new unconstitutional scheme. Just get rid of due process altogether. Extinguish the right of the people to notice and opportunity to be heard by suspending the process that protects that right, the writ of habeas corpus, what we refer to as the great writ. It is the writ, it is the vehicle, the mechanism, the procedure that protects people, citizens and non-citizens alike, from being unlawfully imprisoned, unconstitutionally detained by the executive branch, by the Trump administration. And here's some of the reporting regarding this new unconstitutional scheme Miller, Trump, and others are cooking up. Trump administration's threat to suspend core U.S. legal right sparks outcry and alarm. And that article begins, legal experts and Democrats expressed growing alarm over the weekend that Trump administration officials are openly discussing unilaterally suspending habeas corpus, a bedrock American legal right, without the approval of Congress. The writ of habeas corpus, which dates back centuries, grants anyone detained in the U.S. the right to see a judge, challenge the government's evidence against them, and present a defense. But White House Deputy Chief of Staff Stephen Miller downplayed its significance on Friday, suggesting that the administration could move to suspend it unilaterally. Quote, "That's an option we're actively looking at," Miller told reporters at the White House. Stephen Vladeck, a constitutional law professor at Georgetown University, described Miller's statement on Substack as factually and legally nuts and called it the most remarkable and remarkably scary comments about federal courts that I think we've ever heard from a senior White House official. Other legal scholars strongly challenged Miller's assertion that the president could unilaterally suspend habeas corpus, Latin for that you have the body. And let me just add here, essentially the writ of habeas corpus is a writ that can be ordered, issued by a judge directing the government, the executive branch, to bring me the body of the person you are detaining. Vladeck and three other experts said that a legal consensus has existed for decades, that only Congress has the authority to suspend the right, the writ of habeas corpus. They noted that Article 1 of the Constitution, which describes Congress's powers, states, "The privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it." Ilya Somin, a law professor at George Mason University, called Miller's claim that the president has the power to unilaterally suspend habeas corpus false. Quote, habeas corpus can only be suspended under the Constitution in times of invasion or insurrection. None of that is happening now, said Soman, a libertarian legal scholar and the Simon Chair of Constitutional Studies at the Libertarian Cato Institute. Quote, and it can only be done by Congress, not the president acting on his own. Soman and Jonathan Adler, a law professor at Case Western Reserve University, cited a 2004 Supreme Court ruling in which conservative Justice Sandra Day O'Connor concluded that only Congress has the authority to suspend habeas corpus. Justice O'Connor also emphasized that habeas corpus has acted as a critical check on the executive branch's power, in other words, a critical check on Donald Trump's power to unlawfully detain individuals in the U.S. And one more time, let's go to the guru of all things conservative on the Supreme Court, Justice Scalia. Supreme Court Justice Antonin Scalia, a conservative icon, agreed in an opinion of his own that the power to suspend habeas corpus rests solely with Congress. He also said that the executive branch, the Trump administration, cannot unilaterally round up Americans and hold them in detention without charge, even in times of rebellion. You know, friends, these conservative icons who are revered in Republican circles, Justice Scalia, Justice O'Connor, Judge Wilkinson, all prove to any thinking person's satisfaction that Donald Trump and Stephen Miller are unconstitutional hacks. I would go so far as to call them constitutional cannibals. And yet, what do we hear from the Republicans in Congress? Crickets. I mean, are they really going to let Donald Trump destroy our Constitution, terminate our constitutional construct of government? Or at some point, will they cross the aisle to save democracy? You know, to our Republican friends, I would say, in a world of Donald Trumps and Stephen Millers, be a Liz Cheney, be an Adam Kinzinger. Just cross the aisle to save democracy. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.